What I'm really explaining to you guys, and maybe I'm doing a horrible job of explaining it yet, these are all commercial courts. This is what I'm explaining to you. So if you were here yesterday, we talked about admiralty courts. If you were here the day before that, we talked about commerce and where it comes from and what it does and all of these things, right? All right, well, these inferior courts are established by the legislator. And again, I'm getting ahead of myself because people want the answer to a thing without us understanding a thing, right? So people say, well, what happens when they don't prove jurisdiction? The jurisdiction is a whole nother topic. And that I always get in trouble when I explain, well, we gave them jurisdiction by participating in receiving what they offered, because my dictionaries are not loading fast enough. So we have to understand, okay, well, the Constitution says there are okay, let me say it right. The Constitution, state or federal, creates a corporation. Do we understand that? Everybody tells me all the time, the United States is a corporation. And whatever the United States Code citation is, 12 USC, yada, yada, yada. All right, yep, okay, we believe you. Nobody's doubting you here. Okay, well, in every part of history on the planet, interacting with a corporation is voluntary. Okay? The Constitution creates a government by way of corporation. There's a United States Supreme Court that says that. There's a United States Supreme Court case that says that. That to them, all governments are corporations. I think I explained this yesterday or the day before when going over commerce. No, I was talking about yesterday a Republican form of government. So the United States Constitution says they're supposed to guarantee to every state in the Union a Republican form of government. And we went over what a Republican form of government was. It was actually at the end of the live, so a lot of people weren't there. But they said that a Republican form of government is a government in which the sovereignty is vested in the people. Okay, well, where'd they get that term Republican form of government from? Remember, the Constitution has to be, our Constitution, state or federal, has to be understood and explained by reference to the common law of England. That is the law these people who set up this government in this country wanted. All right? So we don't understand anything in this Constitution if it does not come from the common law of England. All right. So when they say a Republican form of government, we have to go to the history of England. When these people were colonists and they were getting ready to break off from England or from Great Britain, which is the name of a corporation, they had to research what a Republican government was. And they went to the first 10 books of the Bible to understand what a Republican form of government was. Why? Because in the first 10 books of the Bible, from Genesis to 1st Samuel, 1st or 2nd Samuel, I don't remember, they had no king. The people of God had no king. They had no secular government over them. They acted as one large family. They were one large family, and they had elders. And they primarily listened and obeyed to the voice of God. So when they set up these states, and then ultimately this federal corporation that comes up in later, okay, well, they're still supposed to guarantee to every state in the Union a Republican form of government, where the sovereignty is based on the first 10 books of the Bible. They say it. They say, you look at these early documents. I got books on it on the Patreon. They say they studied the Moses and the people of God that were under them. They studied Joshua and the people of God that were under them. And they studied the judges and the people of God that were under them. They didn't rewrite the Bible. You can't rewrite the Bible. They went to the Bible to understand what a republican form of government was. They're talking about a specific clause in the Constitution. You cannot understand the Constitution without going to England. And if you don't believe me, read the Declaration of Independence. They fought the largest navy in the world because somebody was taking away English laws from them. Well, you don't know the significance of that if you don't study English laws. Because what is the common law of England? The common law of England is the immemorial practice of the people of ancient England. Okay, well, there's time periods in this. We're not just making up random stuff. You have to study English law before the birth of Christ, because people don't even know England was around before the birth of Christ. All right, you have to study before the birth of Christ all the way until a certain point in history, which would have been 1066 when William the Conqueror came in and invaded England and took it over. Okay, well, you learn about these people called the Anglos and the Saxons. Well, the Anglos and the Saxons say they can trace their lineage back to the people of Moses. And when we review their laws, they say they can trace their principles all the way back to the Bible. The first 10 books or the first 5 books. Primarily the first 5 books for the law. And then to study the people, you would get that from the first 10 books. Right? So when they set up this, when they get to 1776 and they set up these things, okay, well, what is the purpose of the federal constitution? Because the states already, people tell me all the time, well, there's 2 constitutions. There's not. There was 13 in July 4, 1776. They didn't have a constitution, a federal constitution for 13 years. Well, they were being a republican form of government, where the sovereignty was based on the people. That's why we got things like a grand jury and a trial by jury and an injured party. We don't just say those things randomly because we think, no, that comes from, you can trace those principles all the way back. Where they get a grand jury from? They got it from the book of Judges, where the elders of the family would be the ones that create the cases. Where'd they get a trial by jury from? They say it goes all the way back to a dude named Joseph or Jacob. Jacob changed his name to Israel. Israel had 12 sons. And he taught them the law and the facts. And then you get to the New Testament. They say they got it from the 12 patriarchs as well, the 12 apostles, where Jesus said the 12 would judge the nations. Okay, well, they're just mirroring their ancient principles. But none of those are inferior courts. What is an inferior court? An inferior court is created by the legislator. And you don't get attached to that without your consent. And I talk about consent all the time, and that's when people get mad at me and say, oh, well, the government treated me so badly, they're taking away my rights. No, we gave them up because we didn't know the law. So let me read it again. They said all inferior courts are ones that are under the Supreme Court. So anytime you have to go through an appellate system, remember, I say this all the time, who are the real judges? Not the guy in a black robe. The real judges are the people, the jury. So if you didn't go to them for whatever issue, well, guess who you're dealing with? Because there's only 2 types of courts to this corporation. You went to a commercial court. You went to a corporation court. Instead of going to the people who are the lawful judges of your states, you went to a magistrate who is not legally, whatever that means, or lawfully or constitutionally a judge. He's only a judge over civil matters. Even if they call it criminal, it's ultimately a civil matter. They say you can't even engage with these people unless you've accepted a fiction. They say these people wouldn't even know you were around if you didn't accept fictions from them. But when me too, I'm not a judge. I'm not a false judge. When we participate and don't know the law and engage in things and lose the ancient principles, and then we wonder why we're subjected and wonder why the government's just so evil and bad and getting away with everything, and then we keep going to them like they're the ones that are going to fix the problem, we'll never get it fixed. We aren't going to get it fixed. See, they're not talking about our courts. They're not talking to us. That Constitution is for them. They said we have a law. I prove it in all the states all the time. They say the law of Maryland, the law of Georgia, the law of Texas, the law of California, the law of Washington is the common law of England. People talk about constitutional rights. There's no such thing as constitutional rights to the people. There's only constitutional rights to a corporation. Because a constitution is a commercial document. People say it all the time, and they're right. But they want you to keep going to them for all your issues. So I'm talking about the federal constitution. I'm talking about federal things. So that we understand there's an actual difference. So they say judicial power of the United States should be in one Supreme Court. What's that? That's a commercial court. If you have to fill out papers in order to deal with them, okay, well, guess what? That's a commercial court. Commercial works on fake paperwork. That's what they do, baby. And guess what an inferior court does? Well, that's explicitly all paperwork. That's why all these scammers on the internet keep talking about equity and commerce. Yeah, that's because they're slaves and they love it. And they want to deceive you into thinking that's the only way you can get things done. Because you start talking about this common law of England, they don't ever talk about the common law of England. I heard people say they get held in contempt every time. They say, brother, I read the common law of England. They say, oh, we don't do that no more. Why? Because that's not their law. That's not their law. They have a law. It's called commerce. It's called the law merchant. But we have a law. And it's called the common law of England. And that common law, the people are the judges of the law and of the fact. And if you didn't go to them for the issue, and if your community where that jury was summoned is not competent and know the law, and if you couldn't explain the law to the judges, the jury, okay, well, guess whose fault it is? We can't say, oh, the corrupt government. No. We got to look in the mirror and say, oh, man. Because if you got to fill out paperwork to get it done and have to go through an appellate system, I'm going to go over all this in a second, and have to go through an appellate system, okay, well, that's not the law. It's not our law. Right? So, inferior courts. Do we use the U.S. code? The United States code is not law. I just told you what the law was. What is the law of Maryland? The common law of England. See, why are we in these people's courts? How did you end up in there? I ask it all the time. How did they know who you were? Who told them you were supposed to be in court? How'd they know to put you in handcuffs? How'd they know to tow your car? It's not magic. They don't have superpowers. So somebody had to give them information. Because they say if you don't know them, they can't do nothing. If you're not on the computer, they can't create a case. All right. This is so fun. It's not. Right. Right. Somebody said on YouTube, because we signed papers giving our information. There we go. What does the Fifth Amendment say? People say all the time, the Bill of Rights. Okay, you don't want to talk about the Bill of Rights with me. The Bill of Rights, the Fifth Amendment says you have the right not to be compelled to be a witness against yourself. You have the right to remain silent. The Supreme Court said that comes from the Bible. The right to, okay. Well, that means any paperwork that you fill out. And it's not their fault. You did it. See, there we go. Blaming the government. Oh, it's their fault. It was their fault. No, it was your ignorance. It was my ignorance. Because we stood in line at the DMV without reading any constitution. We didn't read no constitution, man. Get out my face. We didn't read it. We didn't question. We just did exactly what we were told. And then our parents did exactly what they were told. And then our grandparents did exactly what they were told. Yep. So you're acknowledging that we have a master. That's what they said in the Bible. They said the first 10 books, they didn't have a government. And then because they didn't want to obey the voice of God, didn't want to obey natural law. Okay, well, they complained that they wanted a king to judge them like all the nations. They literally said it's in 1 Samuel 17:12 or 12:17. And they say God gave them a secular government as a judgment. Let me see. Yeah. 1 Samuel 12:17. He said, your wickedness is great in asking for a king for yourselves. They said you didn't need a king. But you wanted to flirt with the merchants, the Canaanites, the Phoenicians. You wanted commerce. You wanted Baal worship. Okay, well, we now look at where we're under. Complaining about how wicked the government is. Yeah, we asked for it. What are you talking about? We didn't question nothing. We said, oh, you want us to sign right here? Yeah, great. Yeah. You want a social security number? You want us to take a driving test? You want us to take a computer test? You want us to... Okay. Oh, well, now they're taking away our rights. They're not obeying the Constitution. And, oh, yeah, of course. They said every king after that, every king from Saul. Saul was the first king of Israel. Okay, that dude was horrible. Okay, what happened to King David? He started out real good, real great story. And then he ended horribly. What happened to Solomon? Yeah, it got real horrible. Dude had 600 wives, some odd concubines, had issues with all these contracts with all these foreign countries. Yeah, they said this is what you wanted. What are you complaining about? This is what we getting, exactly what we deserve. When the country started, I think it was Benjamin Franklin. He walked out of some building after some issue or whatever, and they said, well, what have you given us? He said a Republican form of government if you can keep it. Yeah, guess what? We ain't kept it. He said it. Go Google it. I think it was Benjamin Franklin said a Republican government if you can keep it. Well, guess what? We ain't kept it. Right? So inferior courts. I like this definition real good. Let me go back. I say it all the time. If you're learning this stuff from me, we're all in trouble. Because you're not supposed to be learning this from me. If the ball was passed down so many times that it ended in my hands, we're in trouble, boys. If you got to learn the Constitution and the common law of England from me, we're doomed, bro. This is it. It's game over. You're like, how did I get this? I didn't want this. I was living a great life. In ignorance. I was like, yay. I'll pay everything. What you need? Yeah, I can afford it. I ain't have no driver's license issues. I wasn't in court every day. So you learning the Constitution from me? Boy, we all in trouble. Because I'm not it. All right, they said again, an inferior court is any court subordinate to the chief appellate tribunal, and yada, 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 in any particular judicial system. They said an inferior court is a court of special, limited, or statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case in order to give presumptive validity to its judgment. All right, let me go. They actually have their own definition. Let me go to that one. Boy, they shooting it up outside my apartment, boy. All right. An inferior court may denote any court subordinate to the chief appellate tribunal in a particular judicial system, but it is commonly used as the designation of a court of special, limited, and statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case. Jurisdiction by trickery, resident, citizen, elector, are all coerced and yada yada, adhesion contracts. The question is, do you have a driver's license or a state ID, and are you driving cars that they have information on? It's all up to you. You can complain that they did all this evil, and then I can ask you, are you on their computer or are you not on their computer? The end. You can say, oh, they did all this horrible, wicked things to me. But if you got a state ID in your back pocket right now, I don't want to hear nothing you got to say. Because it's all voluntary. It's all voluntary. So you can keep complaining that all the government's so wicked, or you can go live in the woods. Get some actual real skills, go live in the woods. Say, oh, there's no way to be free, we're all slaves. No, speak for yourself. I'm getting up out of here. Somebody said, why you keep teaching it? I need about 200 of y'all, and then I'm out of here. I don't care nothing about this stuff. This is the Supreme Court of Alabama. The Supreme Court of Alabama said that all courts which an appeal or writ of error lies are inferior courts. So this is the paperwork system. This is what I'm trying to tell y'all. There is a difference between common law courts. What are common law courts? What is the real Supreme Court? Because they call it a Supreme Court, but all it is an appellate system. And you study the Supreme Court, well, they don't have no law powers. All they have are the power to give opinions, explanations, and findings. They say this is what we found. Or these are our opinions. Or, I forgot the third thing I just said. So they have findings and opinions, and they only write writs of errors to lower courts. That's their only job. They're an appellate system. Their job is somebody complains, somebody uses the commercial system to go all the way up to the top, and then the Supreme Court has to answer on whether the issue that was brought before them was constitutional. And that can take years. People don't know that. People don't know stuff don't ever make it to the Supreme Court. There's so many cases, there's so many issues that never make it to the Supreme Court. And what's happened over the years is they're flooding the system so that things don't make it to the Supreme Court. So they create a case on anything. And then you appeal because we don't know the common law. So we think the only way to get things solved is by going to the commercial system. Because they don't tell us this, and it's not, in a world of ignorance, it's now not as great. But when a trial by jury makes a decision on something, it's final. There is no appellate system for the trial by jury. Why? Because what the actual judges say is the law in a particular case. Which is good if that jury is competent and knows a little bit about the law and about rights. And it was raised in a world where the 10 Commandments have some weight. But in the world of ignorance, if what they say is the law in your case and you can't teach them otherwise, It's not great in a world of ignorance, which we live in today, right? So, but people don't know the trial by jury is the final say so. I said this yesterday. I said at the time of the Revolutionary War, I read it when they were talking about admiralty issues leading up to the Revolutionary War. Okay, well, they said the governor's courts, which were maritime military courts, would not convict, or they said didn't have jurisdiction, and the common law courts would not convict. What would happen? Somebody would have revenue issues, and because the governor's courts, what are those? The inferior courts created by commercialism, didn't have jurisdiction. When they would bring it before the jury would throw it out. Or they would bring it to the grand jury, and the grand jury would never approve of it. Why? Because they understood rights were being taken away. And when they threw a case out, or if the trial by jury, what they called the petite jury, would say not guilty or whatever, or nullify or whatever, okay, well, that was the law. You couldn't try the case again. That was it. So I'm telling you, I'm teaching you one side of it, just so people understand what the Constitution's about. So people say all the time, well, I learned equity and I filled out all this paperwork and I submitted it to them. Yeah, but it's still up to the subjection of guys in black robes. They don't have to do anything you tell them. People tell me all the time, well, judge, they delay my stuff. I sat in jail for months and weeks and all type of corruption, right? Okay, well, that's what happens when you go to a corrupt system. Instead of investing in a community, which I'm not saying this stuff is easy. I'm not saying we can just do this tomorrow. I'm saying this is why this stuff is important, because you get one good county where you've given them basic information on how the law is actually supposed to work, and you bring this issue before a competent jury, okay, well, they're not going to allow, if they know there's no such thing as a crime where there's no injured party, okay, well, they're not going to prosecute anything or convict anything or find somebody guilty of something where there was no injured party. Or if you got a grand jury who controls everything, who doesn't let any fake cases get through, and they say, nope, we're not prosecuting it. We're not hearing it. Okay, well, guess where the real power lies? Not in inferior and supreme courts. I say it all the time. What is the real Supreme Court? The real Supreme Court is an actual injured party, a grand jury, and a trial by jury. That is the real Supreme Court. And they don't ever have to call it a Supreme Court. But what that trial by jury says is the law. Because why? The Supreme Court, or the Constitution of Illinois and the Constitution of Indiana, says that the jury are the judges of the law and the facts. Not the guys in the black robe. Somebody said, what if you are the injured party? You can request a jury. No, you don't sue. You request a trial by jury. You got to read our state constitutions. All this stuff is in there. We just don't read it. We want to talk about the Federal Bill of Rights and the federal law. No, that's not the law. The law is the common law of England. Suing is commercialism. They didn't call them lawsuits if you had a real injured party. Because what happens when you have a corrupt government? Well, guess who is supposed to be dealing with corrupt government officials? The grand jury. That is literally their job. And we don't control no grand juries in this country. Go study grand jury. Let me read a grand jury to you. They said what the FBI is today is what the grand jury was in England. And that's the people. Let me go to common law. Grand jury. that's not important. Boom, here we go. They said an attorney has no right to give an opinion to the grand jury unless his opinion is requested. They ain't never told a grand jury that. Not in our lifetime. They said the attorney, see, we don't know how the commercial world works. Well, today, an attorney is gatekeeping. We're supposed to be able to go to the grand jury for anything without an attorney. But they put an attorney to gatekeep the grand jury system from us. All right. So they said an attorney has no right to give an opinion to the grand jury unless his opinion is requested by the grand jury. All right. What else? Here we go. They said the grand jury is an institution. This is the United States Supreme Court. They said the grand jury is an institution separate from the courts. They said this is not a commercial entity. Right? Because y'all going to tell me, oh, the United States is a corporation. Okay, well, the grand jury is not. It is an institution of the people from the common law of England. They said the grand jury is an institution separate from the courts. The courts do not preside over the grand jury. They said this is rooted in long centuries of Anglo-American history. They said it is a constitutional fixture in its own right. You're not supposed to be suing for right violations. You're supposed to be going to the grand jury for indictments to put people who claim to be of the government who violate the Constitution in prison. All y'all want is fake Federal Reserve notes. That's all y'all want. And we're never going to get anything done with that. They said the grand jury is separate from the courts. The courts do not preside over the grand jury. They said this is rooted in long centuries of Anglo-American history. It is a constitutional fixture in its own right. They said in fact, the whole theory of the grand jury's function is that it belongs to no branch of institutional government. The grand jury is not a commercial entity. That's what I'm telling y'all. And we're supposed to be going to them instead of writing fake paperwork to an inferior court or appealing up to a Supreme Court. They said we're supposed to have a grand jury and we're supposed to have a trial by jury. It's supposed to be going through the people. Unless you're actually participating in commerce by owning a corporation is the only time that you're supposed to be going to inferior and superior courts. Or inferior and supreme courts. Because that's dealing with commercial things. They said the whole fact and theory that this function belongs to no branch of the institutional government, serving as a referee between the government and the people. They said the grand jury requires no authorization. How much authorization? None. They said the grand jury requires no authorization to initiate an investigation, nor does the prosecutor require a leave of court to seek a grand jury indictment. They said the grand jury generally operates without the interference of a presiding judge. So we could just, see, we never had to go to these people. Ever. Do you understand how important this is? We never had to go to people in black robes to get the situations we had issued or dealt with. Never had to. But they blinded us with commerce and convenience. And now they got TV shows. They don't make no TV shows about no grand jury or a trial by jury. No, they make it about a guy in a black robe. They got Judge Judy, Judge Joe Brown. Okay, well, those are not judges. Right? They got Law and Order where they teach you all. It's all commerce. That's all we know. They said the grand jury generally operates without the interference of a presiding judge, and it swears in its own witnesses and deliberates in total secrecy. They said that you never had to go to the courts, commercial courts, to deal with issues. You understand how important this is? Let me see. That was a power of grand jury. Let's read this. All right. Who is this? This is the Federal Supreme Court. They said the institution of the grand jury is deeply rooted in Anglo-American history. They said in England, the grand jury served as the body of accusers, sworn to discover and present persons suspected of criminal wrongdoing, and a protector of citizens against arbitrary and oppressive governmental action. They said in this country, the founders thought the grand jury was so essential to the basic liberties that they provided in the Fifth Amendment that serious crimes can only be instituted by a presentment or indictment of a grand jury. They said the grand jury's historic functions survive to this day. Its responsibilities include the determination on whether there is probable cause and the protection of citizens against unfounded criminal prosecutions. Here we go. Who is this? This is the Federal Supreme Court. They said the Fifth Amendment provides federal prosecution for capital or otherwise infamous crimes must be instituted by presentments or indictments of grand juries. The grand juries is an English institution brought to this country by early colonists and incorporated in the Constitution by the founders. They said the basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. Grand jurors were the people, and their work was not hampered by rigid procedural or evidential rules. They said grand jurors could act on their own knowledge and were free to make their presentments or indictments on such information as they deemed satisfactory. They said in England they were free from the control of the crown or judges. They said even in England under a monarchy, they were in charge. As long as it was not a valid commercial issue. They were free from the control of the crown of Great Britain or their judges. They said in this country, as in England of old, the grand jury has convened a body of laymen, free from the technical rules, acting in secret, pledged to indict no one because of prejudice and to free no one because of special favor. They said in England, English grand juries were free to act on their own knowledge. What does that mean? That means you could have went and said, hey, these government employees, these police officers, this whoever is not obeying the law. These are reasons why they're not obeying the law, and they have to pay a price for the violation of a constitutional issue. And they said, all right, we'll get to it. And if they determine it be valid, okay, well, they sent an indictment. See, we're supposed to be controlling this corporation. We don't control nothing. And then the grand jury would go get the sheriff and say, all right, we need you to go pick up X, Y, and Z, and we're gonna grill them. We've reviewed the evidence. All right, well, now we're gonna have a trial by jury. And on both instances, you would answer to the people. Yada, yada, yada. They said, yada, yada, yada. They said there's no case that has ever been cited for reversing the judgment of a grand jury. Upon valid evidence. It says that. I didn't say it, but that needs to be, because there are crooked grand juries today in America too. So I'm not naive to say, oh, well, that's the perfect system. No, I know corrupt people are everywhere. They said upon valid evidence. All right. They said concerning the Fifth Amendment relative to the organization of grand juries, recognize that such a jury as being possessed of the same powers that pertain to its British prototype. They said it is a grand inquest, a body of powers of investigation and inquisition, the scope of whose inquiries is not to be limited narrowly by questions of propriety or forecast or of the probable results of the investigation. They said, I'm trying to find one. There's one where they say the FBI gets its is a prototype of the grand jury. Let's see here. Trying to see where it says. Sorry. I'm still talking about inferior courts, by the way, but this is the other side of this. See, if you hang out with me till the new year, I'll only talk about the common law of England. I just want to get these videos made on the Constitution to see where these things come from. Yada, yada, yada. Boom, boom, boom. Here we go. I don't know what case it is, but it says investigative agencies of the executive branch of government are like a grand jury. They said the grand jury is supposed to investigate the investigators. All right. William Blackstone said that the grand jury is sworn to inquire for the body of the county. So there's supposed to be a grand jury. Well, I can't say that, but yeah, there's supposed to be a grand jury in every county. And the grand jury is supposed to know all of their powers. And I bet $1,000 they don't know all of their powers in America today. They said that William Blackstone said that when the grand jury has heard the evidence, if they think it is a groundless accusation, then they would write on the back of the bill, ignoramus, or we know nothing of it. So whenever they would get a fake case where there was no injured party, they would write ignoramus on the back of it. They said, no, we don't know nothing about that. Get on about our face. They said if they believe the indictment is said to be sound, then the party stands indicted. They called it a good presentment or an ignoramus. So if they had a good presentment, they would create the case. If they didn't have a good presentment, ignoramus. They said the grand jury is an institution of English-speaking countries. It has played in some of the most stirring events in history of the Anglo-Saxon race. Remember, that's before William the Conqueror. So that's before the year 1066. All right. I forgot where I was at. What is an inferior court? The Supreme Court of Alabama said that all courts which an appeal or writ of error lies are inferior courts. They may be reviewed, annulled, or affirmed. Any court organized by the legislator may be reviewed by appeal or writ of error. I'm reading this from my Patreon called Constitution Academy. It's $5 a month. It is at the top of my TikTok page. It's the only link on my TikTok page. So I'm reading everything I just read you about the grand jury. I got from law books, or Supreme Court cases. They said any court organized by the legislator. All right, what did we just learn? The grand jury is not organized by the legislator. They said it's not even a part of the court's institutional system. They said any court organized by the legislator may be reviewed by appeal or writ of error and is an inferior court within the meaning of the Constitution. All right.